Most real estate is conveyed through voluntary alienation. In other words, the grantor got rid of the property voluntarily, either through sale or gift. But real property can be conveyed involuntarily as well. These are cases where property is taken from the owner by operation of law. Under the Fifth Amendment to the U.S. Constitution, property cannot be taken without due process of law. The examples of involuntary alienation we'll discuss here are legal procedures. During economic downturns, there's an increase in involuntary alienation cases. So today, it's common to see houses for sale that were seized by banks one way or another. These are the most common types of involuntary alienation. The most common lien is mortgage foreclosure. Even this can be divided into a few subtypes. Bank mortgage foreclosure is the one you'll see most often. In this situation, the owners of the property did not pay their mortgage. Pursuant to the mortgage documents, the note, deed of trust, mortgage or security deed, the lender has the right to sell the property to recover its unpaid loan. Different states have different laws regarding mortgage foreclosure. There are judicial and non-judicial foreclosure states. In states like Florida and New York, which are judicial, the mortgage lender must go to court and get an order allowing the foreclosure sale to go forward. In non-judicial foreclosure states like Georgia and Tennessee, foreclosure can go forward after notice is given to the borrower through mail and advertisement in the local paper. Whichever procedure is required, the involuntary alienation is done by auction on the county courthouse steps. Bidders come for the auction, and the highest bidder wins. The property is then conveyed by the bank on behalf of the old owner to the new owner, usually in a document called a deed under power or foreclosure deed. Another type of lien foreclosure is the tax sale. In this case, the owner did not pay their property taxes, and the county, city, or state, under statutory law, auctions the property to collect the unpaid taxes. This is not as simple as a foreclosure sale. The new owner takes the property subject to all existing mortgages and other liens. Also, the prior owner usually has right of redemption, meaning a period of time to pay off the taxes and buy the property back, whether the new owner agrees or not. A third type of lien foreclosure is levy of a judgment lien. In this type of case, the defendant in a lawsuit did not pay the judgment amount. The sheriff of the county where the defendant lives has the power to take and sell off the defendant's property until the judgment is paid. This can include real estate. Similar to mortgage foreclosure, the defendant is given notice of the sale, and it is advertised in the local newspaper. The sheriff holds an auction, and the proceeds from the sale are used to pay off the judgment. Bankruptcy is another way that an owner can lose their real estate through involuntary alienation. The two main types of consumer bankruptcy use Chapter 7 and Chapter 13. In the Chapter 7 case, the debtor liquidates his property to pay off as many debts as possible. Whatever is not paid off is discharged, meaning it no longer has to be paid. Under the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, the most recent revision of the American Bankruptcy Code, the debtor usually has to surrender his real estate to the mortgage lender to get a discharge of his other debts. If there is no mortgage, the property is sold by the bankruptcy trustee to pay off his debts. Chapter 13 bankruptcy involves the debtor reorganizing his debts. Sometimes the debtor has to surrender property for which he cannot afford the mortgage payments. Another form of involuntary alienation is eminent domain. As we said before, under the Fifth Amendment, property cannot be taken without due process. Sometimes the government needs to take private property for the good of the city or state. Eminent domain is when the government exercises its power to confiscate private property for public use. Before land can be taken by eminent domain, the government must pay fair market value for the property. If the owner and government disagree about the value, the case will go to court for a determination of the proper value. The most common forms of eminent domain are taking a few feet of land along the edge of a road to build a sidewalk. Sometimes the government takes a house or several structures to build a road. Eminent domain has always been controversial. Recently, there have been cases where the government has used the power of eminent domain to seize the land under the guise of public good, but immediately resells the land to private developers. This issue is being considered by the U.S. Supreme Court. Lesser-known forms of involuntary alienation are adverse possession and escheat. Adverse possession is where real property is taken by the open and notorious use of land by another person. Title to property passes to a new owner, essentially by living on someone else's land. The conditions for adverse possession are onerous. Usually, the use of the land has to be for 7 years, and some states require 20 years. The use has to be open and notorious, meaning everyone around sees the non-owner on the land, acting as if he's the owner. And the true owner could have protested during the occupation. Even then, for title to pass in the real estate records, a court has to determine that the land was taken by adverse possession. Usually this applies to property border disputes where a fence is located on another person's land. Another common example of adverse possession is when there are two adjacent lots and only one of them has access to the main road. The owner of the lot which has no access to the main road must pass through the land of the first owner in order to reach the main road. The second lot needs its driveway to pass through the first lot in order to reach the main road and be able to drive in and out of a garage. Escheat is a simple concept in estates of deceased people. If a person dies with property, but there are no living relatives who come forward to claim or distribute the assets of the estate, the property will fall to the state. This happens very often with bank accounts where the family of a deceased person did not know the bank accounts existed. But it can happen with real estate as well.